He is the son of a former president of India. He studied economics at the Cambridge University. He taught coding to himself when most of the senior lawyers had no clue about what a personal computer is. He sat for 15 years at the Delhi High Court and framed jurisprudence in the commercial dockets in areas such as arbitration, tax, corporate disputes, etc. Justice Badar Durrez Ahmed brings to this conversation which very few people can. He has been a judge, he is an arbitrator, and he knows the economics of both the sides. Today, in episode 4 of After the Bench series, we are going to ask him some questions which the Indian arbitration community has only debated so far in the private. Thank you so much, sir, for being with Bar and Bench.
Thank you for having me here with Bar and Bench.
Sir, you spent close to 15 years in the Delhi High Court, framing one of the most commercially active docket of that particular court, whether it tax, whether it be arbitration, etc. Then you retired and you became an arbitrator. What did you discover about commercial disputes the moment you sat on the other side of the equation?
When you are a judge in the High Court and you are looking at commercial disputes, whether it's on the original side or the appellate side,
right,
things are pretty much baked in by that time. In arbitration,
right,
it's like you are doing original side work once again, and everything starts from the very beginning.
Right.
So that is a major shift. Whereas in one jurisdiction you have a review jurisdiction or an appellate jurisdiction.
Correct.
Whereas in arbitration it's purely original jurisdiction, and of course it's purely focused, I would say 90% on commercial matters.
Right.
Because there are other matters like family disputes, etc., which also come in your way as an arbitrator. There's not really much of a qualitative difference in your appreciating the substantive law and things like that, but there is a huge difference in quantitative terms, if I may put it that way. In other words, that you have to do a lot of fact marshalling in arbitration, which is not the case when you are sitting as a judge.
As a High Court judge.
As a High Court judge.
Is it also pointing to the fact that as a High Court judge, many of the judges who are elevated to the High Court do not have a prior trial court experience, and arbitration is, by its nature, a trial. So, do you think you had some difficulty in adjusting to the process initially?
Not really, because I did practice on the original side in the High Court in those days when evidence was taken in court.
Right.
And then, of course, it got it went away to registrars and deputy registrars for recording evidence. So I did have that experience as a lawyer, but as a judge, by the time we took up original side work in the trial court, in the judge, most of the evidence was recorded elsewhere, and you were only looking at the evidence after it has been recorded. And that is one of the failings of lawyers today. High Court lawyers who do not know how to cross-examine or examine witnesses.
Justice Ahmed, a judge is assigned a case. An arbitrator is chosen, sometimes by one party, sometimes by both, or sometimes by the institution. But the very fact as to how you arrive at the tribunal determines the dynamics. Does being chosen rather than being assigned this particular role define how you conduct these proceedings?
See, there are two ways to look at it. One is, if you are a sole arbitrator, then it means that both sides have chosen you.
Right.
Right? You are the arbitrator of choice of both parties. Now, if it's a 3-member tribunal, then sometimes you are nominated by a party, and sometimes the 2 nominated arbitrators nominate you as the presiding arbitrator. So there is some difference in your approach to the matter.
Okay.
The difference being that insofar as I am concerned, insofar as the 3-member tribunal is concerned, once I am nominated as a member of the tribunal, I forget as to who nominated me.
Okay.
So sometimes I ask my fellow arbitrators who has nominated me. So, you must be completely rid of any affiliation to any party.
Okay.
That is one important thing that arbitrators must keep in mind. But if you are the sole arbitrator, obviously both parties have faith in you.
Okay. Yeah. So, but does it matter how you arrive at the tribunal, in the sense, 15 years you were being assigned cases, and suddenly there are people who are choosing you to be adjudicate disputes.
I don't think that really makes any difference, because
at the end of the day it's
the same thing.
Right.
You have to decide fairly and squarely. That's
Justice Ahmed, this brings me to a very important question, because you said something very important, that when you hung up your robes and you entered into the arbitration corridors as an arbitrator, you didn't find much of a difference, because at the end of the day it was about adjudication. Now, this is one of the points in which critics have something to ask you. The critics of the retired judge arbitration model in India at the moment say that former judges run arbitration proceedings like court proceedings. Same formality, same pace, same procedural culture. But without the institutional checks which were there when you were a high court judge. Is that a fair criticism, and even partially when you look at your own practice which is there at the moment?
First of all, I don't know what you mean by institutional checks, because as a judge, what kind of an institutional check do you have? You only have an appellate authority, and that's the Supreme Court, which is the same here. You have a Section 34 or you have a Section 37 appeal on some order. And then of course you have the Supreme Court SLP stage.
Right.
So the institutional checks remain the same.
Okay.
Right. But insofar as the procedure or methodology of an arbitration and a litigation in court, there are two different things. One is that in court you have a particular roster, as you pointed out.
Right.
And within that roster you decide cases. As an arbitrator, you don't have any particular roster, and you have a different set of lawyers in each arbitration, whereas when you are a roster judge, you have the same set of lawyers who are in that field who keep appearing before you.
Right.
So I think there is a wider range of lawyers who are appearing before you. But coming back to the main point that you asked, whether there is any procedural difference and whether it is good or bad for arbitration to have first been a judge, because you carry the baggage of being a judge.
Right.
It depends from person to person. If you want to follow the real formalized procedures of court, then of course it's not a very healthy thing in arbitration. But if you want to adopt your own procedures and try to cut short the entire arbitral process, which you have the freedom to do under the Arbitration Act, then I think that's the way to go. But the criticism is right. If you continue with your baggage of the court and you adopt the same system, same procedures, then you might end up in basically replacing a courtroom with an arbitration
Exactly,
room.
litigation with arbitration.
Yeah.
Justice Ahmed, India has been trying to become a very credible arbitrational jurisdiction since close to 30 years. The Arbitration Conciliation Act came into being in 1996. We have built institutions, we have produced pro-arbitration Supreme Court judgments, and yet sophisticated parties with real money at stake still would choose Singapore or London as a seat of arbitration and not India. What are we actually getting wrong according to you?
According to me, I think first of all there are two or three things. One of the first things is that we do not have, sorry to say that, we do not have a court system which supports arbitration, in the sense that there is a lot of interference with arbitration awards and arbitration processes, as a result of which there is a lack of certainty.
Okay.
And secondly, there is a lot of time which is spent post arbitration. That does not happen in Singapore, or
Right.
that does not
It
happen
doesn't
in
happen.
London, right? And looking at it from the point of the litigant, his interest is not in getting an award. His interest is in getting the money that is given in the award. So once an award is passed, and then it goes through an entire court system once again in the three tiers: single judge, division bench, Supreme Court. Now we have review and also curative.
Yeah, also curative. The DMRC is a big example here.
So that prolongs the whole process, and it is counterproductive to ADR.
Justice Ahmed, in your career as a 15 years in the High Court, there was any point in time where you felt that kind of a pressure from the Supreme Court, because a case could have been an easy dismissal, but you had to spend time on it because you have to give reasons so that the Supreme Court is...
Sometimes you do feel that you have to give reasons unnecessarily when there is no reason for giving any further reasons.
It's very candid, yeah, okay.
Right? But I was a different kind of a person, so let it rest on that.
The single most cited reason, Justice Ahmed, for India's credibility problem as an arbitration seat is, as you said, judicial intervention, particularly through Section 34 of the Arbitration and Conciliation Act, which courts have historically, I must add, that read expansively. You sat on the Delhi High Court for 15 years, watching arbitration awards, come before you, being challenged, etc. From inside that experience, how often was Section 34 used legitimately to correct genuine error, and how often was it a delay tactic dressed in the language of public policy?
See, the person who is aggrieved by an award will obviously, since that avenue is open to him, he'll obviously take that avenue and he will file a Section 34 petition.
Right.
But in my experience, at least insofar as I am concerned, I would always ask the lawyers, tell me what is your strongest point against this award. And if that fails, then everything goes, and I just endorse the award and let it go through to the appellate court. And I, sitting again as an appellate court at a later stage of my judgeship, if the single judge has seen it, if there is nothing glaring about it, then I say put my stamp of approval on it and be done with it. And it doesn't take more than 2-3 hearings.
Right.
But unfortunately, that's not happening.
Any case that comes jarring to your mind?
Not really, but I hear from the lawyers that awards are passed and they are still struggling in courts.
Yeah, because I think Section 34, this is my personal analysis, please correct me if I am wrong, but Section 34 has become another Article 136. Because whatsoever may be the reasoning.
Yeah, because it's so widely worded.
Yeah.
It's so widely worded. Having another shot, that means basically you are having an appeal, whereas it's not an appeal, it's a petition.
Correct.
So it should never be seen as an appeal.
Delhi is theoretically, Justice Ahmed, India's premier arbitration seat. It has the New Delhi International Arbitration Centre, it has the Delhi High Court, which has the most commercially active docket. It has the most trained intellectual bar in the arbitration. But if you are a foreign company contracting with suppose an Indian infrastructure giant, the arbitration clause certainly does not say India as a seat or Delhi as a seat. Why not, and whose fault is this? Again, it's the court?
No, not necessarily the court, but there is a larger system to it, in the sense that we don't have a purely dedicated arbitration bar. There are lawyers who are part-time in court and part-time in arbitration. Right. That takes away time from arbitration, it takes away time from courts also. And I think we must develop a totally dedicated bar for arbitration, who are specialists in arbitration and who know the subject. That is one. The second is that in the courts itself, of course, as I told you, there is a lot of time taken, and mind you, more time is taken once the award is finally a decree, even after Supreme Court, to execute the decree.
Right.
As I said earlier, the litigant is not interested in what you write, he is interested in what he gets.
Right.
Right, and at the end of the day, if it takes him 10 years to get it, what's the point? That's the reason. That's why the comparison between India and some other countries, not all.
What you are saying about developing an arbitration bar was a very valid point, which was highlighted by Justice L. Nageshwara Rao also in our episode 3 of the interview series. But my question, Justice Ahmed, now taking it forward is, what is the solution to that? See, all the law students pass out after their 5-year law course. Some of the privileged ones go on to an LLM in Cambridge or Ivy schools, etc. But at the end of the day, you come back to the Supreme Court or the Delhi High Court, where you have to do a civil case, a family case. You have to keep the pot boiling at home. How do you develop an arbitration bar solely for arbitration? Is there that much scope for the lawyers to be absorbed into the arbitration full time when lawyers themselves are doing arbitration only on weekends?
No, I would disagree with you. There are many lawyers now. It wasn't the case earlier. When I was a lawyer, we used to do arbitrations and weekends only. But now is not the case. Now there are many lawyers who are senior enough and who have had experience, who are dedicating most of their time to arbitration. So for junior lawyers who want to get into the field of arbitration, they should look for such lawyers and join their chambers and then develop from there. I have many cases where lawyers are willing to have matters fixed on Monday at 11 o'clock and Tuesday at 11 o'clock. Otherwise, previously everybody wanted only 5 o'clock.
Yeah, right.
Right, or Saturday and Sunday.
True.
And when I was practicing as a lawyer way back in the 80s and 90s, at that time we were always looking for arbitrators who say कि हाँ भाई Saturday को आओ, come on Saturday or Sunday.
Okay.
Because we were otherwise in court the rest of the week.
In court work, yeah. Okay.
So that was a very sort of an informal adjudication process. Now it's very much formalized, but there's still a lot to do.
Justice Ahmed, emergency arbitration has become a standard practice, whether it's London, whether it's Singapore, whether it's ICC, all have emergency arbitration clauses and parties are using them routinely. India has been a little slow to recognize emergency arbitration. As someone who has been both a judge and an arbitrator, my question is there a legitimate principled reason to be cautious about emergency arbitration, or India's reluctance to adopt emergency arbitration is simply institutional conservatism?
I think it's the latter. There is no reluctance as such, but it's that we have been built on that system of a full-fledged litigation. So therefore, we don't want to go in for a shortcut.
Okay.
Whereas an emergency arbitration, the Act provides for it. We can definitely go into it, but for example, I'll give you an example. There is a huge construction contract dispute. Everything is documentary, and we tell the lawyers, look, everything is documentary, let's forget about oral evidence.
Okay.
Let's get on with final arguments straight away. On one side you have a public sector, on the other side you have a private sector and a huge stakes. The public sector lawyers will usually be very cautious. They don't want to get the blame at the end of the day that you didn't go for any oral evidence and look, you lost.
Okay.
So there is conservatism which is still holding us back from going into fast tracking arbitration.
Okay.
The other thing is that many arbitrators feel that if you are on a sitting to sitting basis, if you fast track it, you get nothing out of it, and at the end of the day you have to write the same huge old award. True. Which takes 150 hours of time. So
that is
writing of the award is one of the most difficult things and most time consuming things that people don't realize.
For a mid-size Indian commercial dispute, for example, Justice Ahmed, of around 50 crore rupees, is institutional arbitration economically rational, or are the fees disproportionate to what the stakes are at?
See, I'll tell you something very simply. Schedule 4, everybody knows about Schedule 4. There is a proportionate fee structure up to a point where you have a cap, say 30 lakhs.
Right.
Now the question is that this was fixed when? This was fixed about 10-15 years ago, in fact even earlier than that. The stakes have gone up. The level of litigation has gone up. Earlier 30-40 crore matters were supposed to be very big.
Yeah.
Right? Now 30-40 crore matters are considered to be at the lower end.
Yeah.
What is happening today is that you have matters where the disputes go into thousands of crores. So would a Schedule 4 be reasonable? That is a question that most arbitrators would like to ask, and that's why many of the better arbitrators do not want to take up a Schedule 4 matter. As a result of which you go into a different set of arbitrators who are not equipped to handle that matter. Okay. So these things also have to be taken into account, and I think it is a very important aspect, because time is money for everybody.
Yes, but is institutional arbitration actually producing better outcomes? Or is the quality of the individual arbitrator the only variable factor in this?
No, in India, you see institutional arbitration, I would think that like DIAC is doing an excellent job. And the other is the old one is the ICA, which was also getting along, going along. But nothing dynamic is happening other than DIAC or the Bombay Center or the Chennai Center. Nothing really dynamic is happening in India.
And why do you think that is there?
I don't know. It's because maybe because the institutions are not proactive enough, and you have a lot of institutional support. For example, if you are doing an ICC arbitration, you have a lot of institutional support.
Right.
In the sense that there's somebody who is always pushing you to do things. Right. In fact, even the awards are reviewed before it is finally published. So they are reviewed in the sense that they don't tell you whether you have gone wrong or right or whatever. That is not their domain. But they say, okay, you have not dealt with this matter, you have not dealt with this matter, you have not dealt with this matter. So they point that out, so that later on the award becomes rock solid.
Oh. So that kind of correction.
That kind of award review is not done in the Indian institutions at all.
So you think it's high time for
I
us
think
to
we should adopt all the good practices. Somebody should look into it, and see, okay, look, all right, this point was argued, you haven't dealt with it.
Okay.
Please deal with it. Whichever way you want to deal with it, but please deal with it.
Justice Ahmed, I wanted to ask you this question, I missed it. If a party came to you as an emergency arbitrator, needing an order before a transaction closes, the following morning, do you have the powers under the current Indian law to actually help them?
They can, if it's a prolonged arbitration, they can ask for a Section 17 and get an order. But if both parties want to come to you and say, okay, please decide by tomorrow, right, one way or the other, it's for them to give me that jurisdiction. I can do it.
Right. So it's all in the agreement.
It's all in the agreement. They can even agree for a non-reasoned award. Nothing prevents them. It's only the act which says that I have to give reasons for an award. Suppose two persons come to me. Suppose, let's take it as a family dispute. Two brothers fighting amongst each other. And they say, okay, we want this decision by tomorrow or day after or whatever it is. And you need not give a reasoned award. We have full faith in whatever you decide. I can do it.
Okay.
And then that cannot be challenged either.
Right.
Earlier we had the system where you could have a non-reasoned award. But now, of course, you have to give reasons as per the act, unless the parties bestow that authority upon you to give a non-reasoned award.
So you can?
You can.
If the parties choose to?
Yeah, if the parties choose to.
Justice Ahmed, the Indian arbitration market is dominated by a relatively small group of retired senior judges and a handful of senior advocates. Of course, I'm talking about arbitrators. Fees in large arbitrations can be substantial.
Yeah.
Critics say that this has produced a concentrated market with high barriers to entry and fees that sometimes bear little relationship to the complexity of the dispute. You are inside that market. Is that criticism fair?
To a certain extent it may be fair, but you see, for one thing, I never refuse any court-ordered or directed arbitrations, whatever the stakes may be in the value of the dispute. So sometimes you get very low value disputes, but which are highly complex. You can have a very low value dispute which can be very complex, and you can have a very high value dispute which is very simple, involving just one question.
True.
Right? So it depends from matters to matter, and the fee structure, ultimately, according to me, everything averages out.
It does average out.
It does average out, because sometimes you do a low paying case which is probably given directed by the High Court. I never refuse that, and it may be a very complex thing, and I may be spending much more time on it than in another very high value case which requires only one issue to be decided.
Right.
But lawyers do make much more than the arbitrators.
Because I'm personally
When you
privy
see the
to-
statement of cost, then you know.
absolutely, because I've been hearing about a lot of arbitrations where the issues are not that complicated, but when the arbitrators really ask the counsels that how many days would you take to cross-examine this particular,
Yeah, huge.
they say 8 days,
Yeah.
and
Yeah.
the questions are very simple
Yeah.
to ask. So
Yeah.
and 8 dates is perhaps across 8 months.
Yeah.
So that's the entire thing. Yeah. Party autonomy is the foundation of arbitration. This is Ahmed. What the parties agreed to governs, as correctly said by you. Even if you have to decide a dispute tomorrow, if the parties say you can do that. But Indian courts have found that autonomy is limited by public policy, is limited by the non-arbitrability doctrine, is limited by mandatory statutory provisions. As an arbitrator, Justice Ahmed, where do you draw the line between respecting what the parties agreed to and protecting what the law wants?
Whatever arbitration matter comes or dispute comes before an arbitrator or an arbitral tribunal, it has to be decided within the four corners of law. That's the substantive law of the land, right? But within that four corners, there is a lot of elbow room. There's a lot of play which the party autonomy can grant to the arbitrator. For example, procedure. Right? Procedure is one aspect where the tribunal is in total control of the procedure.
Okay.
And if the parties agree, and particularly the lawyers of the parties agree, things can be sped up like anything and can be simplified. Party autonomy is if I would say, the sine qua non of arbitration.
But within the four corners.
Yeah, you can't go out of the law.
Right. One persistent criticism which has been there for long from arbitration from foreign parties and foreign councils, etc., has been that, as we were discussing, the evidentiary phase in India is managed too much like Indian court proceedings. Document withholding, excessive objections, cross-examinations running for days. Is that criticism fair, firstly? And as an arbitrator, what powers do you actually have to manage evidence efficiently when one or both parties are determined to litigate rather than arbitrate?
Criticism is fair. We do spend a lot of time in recording of oral evidence.
Right.
In most of my cases, I tell them, look, everything is documentary. Why do you need oral evidence? And if there is any gap that you want to fill, you can use interrogatories, serve it on them, get your answers and be done with it. And it has worked. But as I told you, the constraints, some lawyers insist upon having oral evidence. Some parties insist upon their lawyers to have oral evidence, and they are bound by the instructions, and probably they can't override them. So that difficulty remains. One way out of this, which I have found out, is to have transcription services.
Okay.
Real-time transcription, so that long-winded cross-examination going on for days and days and days ends. I'll give you an example. Just recently we had a matter in which the counsel said that I will take 5 days to cross-examine. I said, all right, but we will use transcription, real-time transcription. And in 3 sessions it was over.
What happened? He couldn't ask the
He
same
couldn't
questions.
ask any more questions. It was over. Because it was real time, so he has to be quick about it, isn't it?
Okay.
So that's
But
the end
again,
of
this
it.
is something the parties have to agree to.
Have to agree to, but this is something which the tribunal can. I told them one thing. I said, look, 5 days will cost you more than 2 days if you have transcription services. It is better to have transcription services. It helps the clients, but it may not help the lawyers. I'm sorry about that.
And they agreed to it.
They agreed to it.
Okay. That's a very interesting take. So that's one of the ways to manage evidence.
Yeah,
efficiently.
it is happening now more and more frequently.
Okay.
In fact, some of the lawyers are themselves suggesting, and they are the younger lawyers who are themselves suggesting, why don't you have it on real-time transcription? Earlier it was very expensive because people used to come from London or Singapore or Hong Kong, but now it's within India itself.
Justice Ahmed, this is perhaps one of the questions I've not asked in any of the arbitration interviews so far. Parliament legislated the Arbitration Council of India into existence in 2019 to do something India had never done. That grades institutions, a body that grades institutions, accredits arbitrators, sets professional standards, and maintains a national repository of awards. The enabling provision, if I'm not wrong, sat unnotified for about 4 years. The council was never constituted. In 2025 January, the Supreme Court had to nudge the government as to what are you doing about the Arbitration Council. You practice daily in a market where that this body was supposed to regulate this particular body. What does that silence tell you about how seriously the executive actually means its own arbitration reform agenda?
See, I think that they have legislated, but they have not put it into action.
Right.
As of now. And there may be serious concerns about gradation of institutions and gradation of arbitrators and tribunals. Because one of the biggest problems in India, I haven't really gone into the depth of how they are to grade, etc. One of the biggest problems in India is subjectivity. So how do you grade an institution A above institution B? How do you grade an arbitrator A above an arbitrator B? And that subjectivity, I think, if it comes in, it will do more damage than good for the system. So that's one of the problems that I have with that.
The Arbitration Council.
Arbitration Council, unless and until I study it in depth and see how the gradation is to be done.
Okay.
Because that can lead to very incongruous results. A useless institution may be graded as number 1. Then what happens? It brings a bad name to the country, and that's the end of your whole system.
Okay. Any other pitfall that you see in the ACI?
I haven't really gone into it in depth, so I wouldn't like to comment. But this gradation system is definitely something which needs to be looked into with great care. The
government is India's largest litigant in arbitration, as with other cases. Yet, the ACI is designed as it gives the government dominant control over its composition. Singapore's model works precisely because the government does not control SIAC. Is India trying to build a regulator that is structurally incapable of earning the confidence it is supposed to generate?
I would agree with you on that, because such a body should be autonomous and it should not align to any party. And as you say, the government is the biggest litigator or biggest party involved in disputes. It should not have any say in the matter.
But then how do you form a regulatory body without any government?
Why not?
How would you have the
Why
members?
not?
We'll have a committee.
You have a committee, let it regulate. One of the litigants in the big high-stake matters be the controlling power there. Any government, it doesn't matter which government.
Of course. Justice Ahmed, assuming the ACI is eventually constituted, its most consequential function will be accreditation, because that's why it is there, creating a genuine professional standards, etc. In India right now, there is no such standard. The market self-regulates, which in practice means a small group of retired judges and senior advocates dominates the practice with no external accountability to anyone. What should a credible accreditation framework actually look like is my first limb of the question. And how do you prevent it from simply formalizing the concentration that already exists?
I find that there are many arbitrations in which you have engineers also.
Right.
And former bureaucrats.
Absolutely. Construction, I think, is the biggest example to that.
They do a pretty fine job in, as an arbitral tribunal in helping out on technical issues.
Right.
But on legal aspects, they do need somebody who has had some sort of a judicial experience, whether it's a lawyer or it's a judge, it doesn't matter. So that things are put in the correct perspective.
Right.
Now, when you talk about accreditation, how do you go about doing that? How do you say that this institution, suppose somebody starts an arbitral institution on day 1, how do you give it a rating? Let's put it that way. Like you have in stock market, AAA plus or whatever it is. How do you give it a rating? On what basis? There could be one basis could be that they decide very fast. Number 2, that their awards have not been set aside by courts.
Right.
What is the basis for that? There is no bias involved in their awards. See, these are the most important things that in an arbitration is integrity and equality for the parties and a fair decision. That's all that they want. The parties want that I am going to a tribunal who will deal with my matter with integrity, will not be biased, and will give both sides an equal opportunity and give a fair decision.
Correct.
Of course, many parties want to be unfair, but at the end of the day, the lawyers who are representing those parties, all that they want is that they should be heard properly, their matter should be considered, and a fair decision should be given. That decision may be right, may be wrong, but it should be a fair decision.
Right. So you think all of these reasons are bottling up together to not notify it formally?
Yeah, it's difficult.
Justice Ahmed, an international commercial lawyer, choosing a seat today has Singapore, Hong Kong, London, Paris, Geneva as serious options. Each offers enforcement predictability, institutional credibility, and a legal culture that actively supports the arbitral process. Can India make it to this list in the next 10 years? And if yes,
it can.
What specifically needs to happen for that?
It can make it to the list. As I told you, the major factor here are the court system. The major factor. I am not saying it because I am a retired judge. I am saying it because I feel for it. I want that the court system should support the arbitral process to make it happen faster and to make it more certain. Why should there be so much uncertainty?
Has there been a case ever that of course all your awards must be very well reasoned, but has there ever been a very case where one of your detailed award gets set aside by the Supreme Court? And
at least I haven't come across.
Not yet.
Not yet.
An arbitral award is not a judgment, Justice Ahmed. It does not need to follow a precedent. It is generally not published.
Correct.
It can be challenged only on limited grounds. But it is also in many cases the final word on a dispute involving hundreds of crores. What standard of reasoning do you hold yourself to when you write an award is the first limb of the question. And should arbitrators be held to a higher or lower standard of transparency than judges, given that there is no publication and no binding presidential obligation?
First of all arbitral proceedings are supposed to be confidential.
Absolutely.
That the Act says so. And the only part of the dispute that can be made public is the award when it goes for execution or the award when it is challenged in court.
Right.
And then of course everything becomes open because all court proceedings are open proceedings. See, the most important thing here is that when you sit as an arbitrator, you have to look at the arguments raised by both sides. And you have to arrive at a conclusion after considering the arguments of both sides. Now you give your reasons,
right?
Whether it is in 10 pages or whether it is in 5 paragraphs or it's in 50 paragraphs.
Correct.
You have to give your reasons, you have to deal with that. So to that extent, you are transparent insofar as the parties are concerned. You may be opaque insofar as others are concerned. But your transparency to the parties is very much there. Your award says so.
Right.
They are transparent but only limited to the parties because it is a closed room dispute resolution system, not like an open court where anybody can walk in and sit and watch any case.
Right.
Right. And sometimes if there is a leakage, it can cause a lot of problems. For example, there is a share purchase agreement dispute going on. A big company, right? And if it leaks out as to what is happening there, the prices may fall to such an extent that that company may be ruined. So confidentiality is a very important aspect in arbitration, whereas it may not be in a court.
Usual litigation, yes.
Yeah, in a court matter, unless of course it says that we have to have an in-camera proceeding or whatever.
So the last limb of the question was, should arbitrators be held to a higher standard of transparency than while they are judges?
I think they have the same standard of transparency because every award is looked at by the parties, and section 34 places it before the court. The court has a look at it. It's absolutely like an open book. and the courts know where you are right, where you are wrong.
The Arbitration and Conciliation Act was amended in 2015, 2019 and 2021. Each amendment trying to address a problem the previous version created. You have lived under this act and as a judge applying it and as an arbitrator operating under it. If you were advising the Law Commission today, what are the 2 or 3 things that remain broken and no amendment has yet fixed?
One of the things that comes to mind is, I suppose they could in some way bring in some sort of legislation which cuts down the time for execution of an award and not be treated as an execution of a decree, because that also takes a lot of time. You have won the case, you have gone right up to the Supreme Court and finally become victorious, but where is the money? So that execution takes time, and if it is executed as a decree, execution, there used to be an old saying that half the battle is the execution process. The other half you can take 5 years for execution, you will take another 5 years.
Okay.
So I think that's one area where a different route should be followed for execution of awards.
In the foreign jurisdiction that we were speaking about, how are the enforcement of awards carried out?
Their enforcement of decrees are much faster in any case.
Okay.
So here, because the decrees are being enforced in a very sluggish manner.
Okay.
You have an execution petition, then you have an execution appeal, then
it just keeps going on.
Yeah, it keeps going on.
So, but do you think this is
ultimately you won?
Yeah. So this is one of the chain that is pulling.
Yeah, that is stopping, because ultimately, when an international player wants to see that he is going in for arbitration, and which should be the court which has curial jurisdiction, so he would go to a court where he can get a quick relief. He is not interested in going to a court where he knows that he will get the relief, but maybe after 5 years, 10 years.
So the court enforcement of court awards are faster.
Yeah, much faster
than the arbitral awards.
Yeah.
So have you ever really spoken about this issue? Because I don't think it's spoken about much. That if court awards are being enforced faster, then how do we tell litigants?
Court decrees are being,
in the sense, court decrees, yes.
In India, are a tedious process. And the arbitration awards are to be executed as a decree under the Act.
Of course.
So they follow the same procedure, the same tedious procedure.
But just tell me, Justice Ahmed, as a judge, if you today would have resolved a dispute in court in 5 hearings and passed a judgment as a superior court, suppose for example the Supreme Court of India, the judgment would have to be complied with.
That's what you think. You ask the lawyers what happens in execution.
What are the tricks up their sleeve?
They file an appeal. There are so many applications that can be made.
Okay. So I think this
you have to go to the
litigation rigmarole is something that
I'll tell you out of personal experience. There was a family litigation which lasted 50 years.
50 years?
50 years. Ultimately, we won in the Supreme Court, and it's still at the stage of execution.
Still?
Still.
When was the Supreme Court?
2019. So now parties have decided, let's sort it out amongst ourselves.
So the entire battle, judicial time goes to waste.
Judicial time, what? People have died, generations have gone. So this is what happens in India.
So you think a legislation can target it?
Legislation has to be there to help the courts to get on with it.
You have been in the law for over 40 years, Justice Ahmed. You've seen Indian arbitration from every angle. As a practicing commercial lawyer, the High Court judge for 15 years and now as an arbitrator for close to 8 years. If you could change one thing, not two, not a list, just one thing, that would genuinely transform India's arbitration landscape, what would it be?
I think the most important thing would be procedure. We have to cut down on procedure. Whether it is before the tribunal, whether it is before the court, whether it is before the executing court, procedural delays has to be cut down.
And what is that one thing that you are most pessimistic about, if I may ask? The thing you believe will not change regardless how many amendments we bring, and what are we likely to still be discussing 20 years from now?
We are not professional enough. That's the problem.
Could you elaborate? What do you mean by it?
Lawyers taking adjournments, that's unprofessional. I can understand if some huge calamity has come upon. That's unprofessional unless and until such a thing happens. If you're just inconvenient for you, lawyers taking adjournments. And without lawyers, the system won't work. You know that.
Right, absolutely.
There has to be professionalism, and of course there has to be professionalism amongst the arbitrators and arbitral tribunals also. You have to be strict about it.
So that's something that's not going to change 20 years from now, you say?
It's not going to change it doesn't look like changing in the near future. Unless, I say, it's all parts of a jigsaw puzzle. And one of the most important parts of the puzzle is to have a dedicated arbitration bar. What happens is, suppose I fixed a matter for, say, today is Thursday, tomorrow is Friday. Right? And suppose the courts were in process and not during vacations. Suddenly, I'll get an email saying that there's a matter fixed before the Supreme Court tomorrow itself. So please adjourn. So now, in deference to a hearing before the Supreme Court, we do adjourn. What can we do about it?
But if it was an arbitration-focused lawyer, then probably that...
Yeah, that wouldn't have happened.
So that cuts delays, you say?
That cuts delays. And some lawyers, they say, are professional about it, and they say, no, I've got a hearing fixed tomorrow, I won't take up that brief.
So that's what you mean by when you say professional?
Professional.
Thank you so much, sir. Thank you so much for your time. It was lovely speaking with you.
Thank you, sir. Thank you.